Yes, Mr. Heppenstall.
My Lords, my Lady. I'd just like to start with dealing with a few general matters before I get straight into ground one. The first is, could we return to the directive and Annex 1 essential requirements? It's internal page 29 of the new clip of directive that you have.
Yes.
Because I do just want to very briefly, with trepidation, return to my Lord and Lord Justice Snowden's bone, because when it comes to adjectives in the public, in the product safety arena, the central test, as it's been since the 1980s, is whether there is a positive risk-benefit balance. That is the ultimate test that is applied in the product safety arena, because you can never say safe and you can never say unsafe. It is always a balance between.
I think you can sometimes say unsafe.
Well, the balance, it will be where the balance is struck, but the test is, has the product got a positive risk benefit balance? And you can see that writ large in Annex 1, in paragraph 1, the final words, when weighed against the benefits to the patient are compatible with a high level of protection for health and safety. You can see, particularly in paragraph 6, any undesirable side effect must constitute an acceptable risk when weighed against the performances intended. In the medicines field, regulation field, the example given is often a very aggressive cancer treatment, which has horrendous side effects, but sufficient benefits for it to be lawful on the market. In the medical devices field, one product that has detained these courts is metal-on-metal hip replacements, which have been judged by the High Court in general to have this positive risk-benefit, because despite the fact they carry a risk, for most people it means they can walk, or walk in a better way than they did before. So that's the test. You look at the rough and the smooth, you look at the pros and the cons, and you decide whether that balance is struck. So that's the, and you'll find that in most pieces of European-based legislation. It is also now the accepted test for product liability under the Consumer Protection Act, which of course is based on the Consumer Protection Directive. And it makes sense, of course, because as doctors like to say, medicines are poisons. They are mostly not homeopathic and natural to the body, and they're going to have downsides. And the same can be true for medical devices. So to take this product, that is precisely the sort of lens that you look through. Now, can I also, you'll notice if you look at 6A, whilst we're on page 29, demonstration of conformity with the essential requirements must include a clinical evaluation in accordance with Annex 10. And it's that clinical evaluation, which if you turn forward to page 62 in Annex 10, which is the central part of the underlying dispute. Because you establish compliance with these requirements, if you look at 1.1 through and 1.1.2 and 1.1.3 at page 62, from a number of different means. That's why it's starting 1.1.1 with either, and there's two ors. But the first one is looking at equivalence, an equivalent device. And you can see the relevant scientific literature currently available. So when they're talking about state of the art in terms of the scientific literature, it's the currently available. And what has happened here is that the cell AED was assessed by BSI as equivalent to the Philips heart start, and then it wasn't. But you can imagine the moment it isn't assessed as equivalent, the manufacturer has to reinvent the wheel. It was relying on all the data, the scientific data related to the heart start, and now it's got to reinvent all of that data for its own product.
When you say it's assessed as equivalent to the Philips heart start, do you mean it works in the same way, or do you mean it has the same clinical effect?
Well,
or both?
Well, or that's what scientists and technicians endlessly debate in this regulatory arena. So that there are guidelines as to what equivalence means that come out of the European Commission, but they are just guidelines, and people debate that issue in this product safety arena routinely. My case is that the RRR is equivalent because it generates the same clinically significant waveform that produces the current as its equivalent products, as the rest of the market, in fact. The science is, despite Philips calling theirs the heart start, the science is not in fact to restart the heart. The science is the heart is in arrhythmia, and its rhythm needs to be corrected by the application of electrical current. That's how these defibrillators work. And whoever wrote, the person who wrote the paper you were shown, who said that the biologically significant aspect is the current, is absolutely right.
I didn't think the defibrillators work to correct an irregular or arrhythmic heartbeat, because I thought they all shouldn't work if they detect a heartbeat.
Well, they're detecting a heartbeat that needs correcting, is my understanding of rhythm that it is in arrhythmia and tachycardia, and needs to be reset back to a normal rhythm.
As opposed to a heart that just isn't beating at all.
Yeah, exactly. So
I thought defibrillators were supposed to work on somebody whose heart has stopped.
Well, they might be able to get it back into a rhythm, but the technology is focusing on the current, and I'll show you where that is in the evidence in my client's evidence that was before Mrs. Justice Laing. But
when you say your product, which I think is called Cell.
Someone's giving me one, the Cell AED.
Oh, is that
that's a trading model. It's not live. It's not charged.
Right.
So it's arrived from Australia this morning, as I understand it. So that's it.
Well, that gives us quite a good idea of the portability of it.
Yeah, it's 300 grams. The portable Philips heart start is, for example, 1.5 kilograms. So it may be portable, but it's just not as portable.
When you say, so my question was, when you say it was assessed by BSI as equivalent to the Philips heart start,
yeah.
Do you mean that was the one on the basis of which you got certification in Germany and
wow,
which was then passported into the UK?
Yes. Can we just test the light touch passporting though for a moment? I don't want to dwell on this, but my learned friend.
Well, I was just asking what the facts were, what you meant by saying it was assessed as equivalent to Philips heart
start. So
start.
we rely on the Philips heart start.
And that has clinical data.
Yes.
Which shows that it works.
And has the positive risk benefit balance. Yes.
And you say because ours is equivalent.
Yes.
That's sufficient to show that ours works.
Yes. Yes. And the reason for equivalence in European law is you don't want to test the same product, equivalent products, on humans, or in fact pigs, I think, are commonly used for defibrillators, over and over again. You shouldn't be doing that clinical testing over and over again. The last time I was in this court on equivalence was about sparrows and slug pellets. And we were saying our slug pellets are equivalent to these other slug pellets because we don't want to put more sparrows at risk. And in fact, under European law, you're not allowed to. You can only put the sparrows at risk, or the pigs at risk, or the students who get defibrillators tested on them at risk if you can't point to an equivalent product.
I'm still struggling with this question I asked a little earlier. Picking up my Lord's point, Is it said that your device produces the same waveform and current as the Philips heart start? Or is it saying that, no, we accept it's different, it's different in weight and size and produces a different waveform and current, but it has equivalent clinical effects? Which one or both of those?
It produces the same clinically equivalent current, clinically significant current. So it produces the same level of current as the other devices on the market to correct arrhythmia.
The same current?
The same clinically significant peak-to-peak current. Can I show you page 77?
And this is because of the way that the capacitors that are used to produce the current discharge.
Exactly. So the innovation that my client has developed is that the capacitors on them, the incumbent capacitors, the incumbent defibrillators have one capacitor, and they use between 120 and 150 joules to produce this biphasic waveform, which is actually split 70% of the emphasis on the first peak and 30% on the second. Our innovation is to use multiple capacitors, so you use less voltage, and you split the currents, the way the current works on the biphasic wave, 50-50 rather than 70-30. So we're using more capacitors, which means we're using overall less energy. I think the evidence is 75 joules.
So in pure electrical terms,
yes,
it's not equivalent. You say it produces the same clinically equivalent result.
Yes. Right. Yeah, exactly. And if you want the reference, it's page 77, paragraph 16 of my client's witness statement, where, in fact, she's quoting the marketing blurb on the RRR Cell AED website that sets out how it works and how it's different. Now, I was just going to go to core bundle page 196. This is a letter from BSI. It's a letter that shortly came after the appeal letter, 27th of February 2024. But what I'm interested in is there's a quote, page 196, paragraph 2.5, of BSI conveying some information to MHRA. And if you look at the third paragraph in italics, it's telling MHRA that they completed a pre-transfer review. So that's transferring the CE to CA. And the results of the DQS, that's the German counterpart, notified bodies' assessments were shared with BSI and were taken into consideration, etc., etc. And then you see the next bit, paragraph. As part of the technical review, i.e. the one mentioned above, clinical evaluation was covered and the device in question claimed equivalence to the heart start, which was accepted by the reviewer, and the clinical evaluation covered data based on this device. Technical review, you see in the last sentence, also covered the energy delivery as we seek all waveforms and meets the state of art of the relevant standard. So,
I'm so sorry, I've got the wrong reference.
page 196 of the core bundle.
Thank you very much.
So we do take issue with the idea that it was light touch, and we do take issue with the idea that there hasn't been some sort of change of mind or moving of the goalposts. We said the goalposts have significantly moved, and if you think about it, you are relying on another product's published clinical data. And then they say, you need to submit a plan, because you can no longer rely on that data. You have to reinvent the wheel in 90 days. It's an utterly unreasonable position for BSI to take. And to take that position through an unfair, unjust, irrational process you see in the statement of facts and grounds. I won't go through it. And then just whilst we're in the evidence, can I ask you to take note of page 92 of the supplemental bundle and the last few paragraphs of my client's witness statement that set out the evidence that was before the learned judge below as to the devastating commercial impact if the UK CA certificate were removed. And I'm afraid we do have to be realistic about this. The reliance on the CE mark is a bit like saying, Legal 500 say, I am a poor advocate, and I say, well, don't worry about that. Let's look at what Chambers and Partners say. We have to be realistic that if it is public knowledge that we are not certified by the UK notified body in this jurisdiction, that will mean that we cannot, in all good conscience, market the product. Imagine the explanation that's going to have to be given to customers. Apparently, we're not meeting the UK tests, but we are meeting European tests. Would you like to try your luck with this product? It is not a commercially sustainable position. My learned friend, when he was in the medical devices regulation, took you to the sort of domino effect regulation, which is that BSI inform MHRA inform the other regulators, and all of a sudden, everybody, all the marks have to be defended. And even if we are successful overall, the commercial damage is done. And as the learned judge correctly noted in a judgment, this is a start-up, innovative company who is trading word of mouth to mouth, word of mouth, as actually those are the words of my client in her witness statement. And its reputation is everything, as it goes to the market, as it seeks to raise capital. And the idea that it could just say, well, the UK's decided they don't like our certificate, but that's all right. We'll trade as long as we dare on the German certificate alone, is not sustainable. That's not a way in which we could retrieve the commercial situation.
Do we have evidence as to how rapidly the information that the UK has suspended the certificate or failed to renew it would have consequences in other jurisdictions?
Well, I mean that would be up to regulators. I mean, they've got a statutory duty to inform on suspension, and the other regulators obviously be very interested that the product has been suspended on the UK market.
Yes, I see.
Yeah. How fast? I can't speak to how fast other countries' regulators would move.
React.
And anyway, the regulator is important. The market response is also very important to my client for obvious reasons. And you will have seen in the papers, you don't need to go into it, the allegations that my client is making about is the market behind all of this anyway. There's already heightened market interest in this innovative product. So the market is taking a keen interest in it, and the market would know and would react to the suspension.
You're selling to consumers directly?
It is on our website, yes, but we also sell to other bodies,
intermediaries.
Yeah,
yes,
and to the NHS. You can imagine how this might be useful to the NHS, and the NHS commissioning powers that be have us on their list. Although, again, taking a very keen interest in liaising with MHRA about these proceedings, which is a stark reality for my client, and it's why it's in court. And that is what's on one side of Mrs. Justice Lang's balancing scales on the balance of convenience. That's the weight that's on one side. It's very important to my client. Now, with all that out of the way, let us get into ground one. And
sorry, did you give us the reference to your client's witness statement?
Page 92, supplementary appeal bundle, paragraphs 53 to 61. Now, on ground one, I think actually the answer is very straightforward. I think my learned friend is making a category error. Mrs. Justice Laing was not sitting in the Medical Devices Regulation Appeal Tribunal. She wasn't there to decide if BSI had complied with the statutory framework. The test before her was the American Cyanamide +++ for public law context. So when my learned friend says BSI swims in the waters of the directive and the MDR, true, but Mrs. Justice Laing doesn't swim in those waters.
Sorry, I'm not sure I follow that. It's an application for judicial review, and in order to get permission to apply for judicial review, you have to show there's an arguable error of law, in short. And in order to succeed, you have to show that the regulation was erred in law. So at the moment, I'm not following how it's just unvarnished American.
Well, I think that takes my submission too far, my lady.
Right.
I'm not submitting, obviously, that if she were to decide the JR, or when she's deciding serious issue, or when she's deciding the strength of the claim, she's not going to ignore its legal context. She's not going to ignore the arguments I'm putting forward that BSI have not complied with that statutory regime.
Right.
But the balance of convenience test and the things you take into account, that's the exercise of the court's equitable jurisdiction, taking into account all relevant circumstances.
No, it's not. It's a question of whether you get interim relief on an application for judicial review.
But I think the parties agreed, my lady, that it's American Cyanamide plus the judicial review adaptations to that test. That's the law that she must apply.
No, but the overall context is that you're applying to the court on the basis that the regulator has erred in law. So you've got to have some kind of an argument that there's a legal error by the regulator. Otherwise, you don't.
Absolutely. That's stage one.
Right.
When it comes to stage two and the balance of convenience, my learned friend's argument is that she made an error of law in not conforming in her analysis of risk to public safety solely to the parameters of the directive and the medical devices regulation. I would flip it the other way around. Had she have done that, she would have been fettering the very wide equitable discretion that she has under the balance of convenience. You're making a category error. So when she says there's no evidence of this product posing a risk to the public, she's merely describing the evidence that the reason why this product is being threatened to taking off the market is because of the equivalence decision. It's because all the data it had to demonstrate it was complying with Annex 1 essential requirements is being taken away from it, such that it doesn't have that sufficient data. That's what's happening. What's not happening is that somebody somewhere is deciding that it's lost, it's dangerous. That's all she's recording in that part of her judgment.
I mean, so you're saying, well, you accept that when looking at the first stage, is there an it's a good arguable case or an issue to be tried? The first sort of threshold question, if you put it this way, that you have to take into account this is done in the context of judicial review.
Of course.
Where you've got to show an error of law by a public body.
Of course.
In the conduct of it.
By reference to the applicable law, which is the directive and the regulation.
You then move on to balance of convenience, which is the American Cyanamide approach.
Yeah.
Which requires you to look at two hypotheses. One is, I grant the injunction, it turns out I was wrong to do so.
Yeah.
Second, I don't grant the injunction, it turns out at the end of the day, I should have done.
Yeah.
In other words, so and you look at the two hypotheses and you ask, potentially, I think, what's the risk of greater injustice is the way it's often put.
Exactly.
But in doing that, you have to evaluate that you're not just dealing with two private litigants engaged in a contractual dispute.
Yes.
One of the litigants has a public function, a public duty to serve the public interest in relation to health and safety.
Of course.
So when you're conducting that balancing exercise, you do have to give greater weight to that, don't you?
Absolutely. And if I were in a situation where evidence was before the court that my devices kept sparking and electrocuting people, then I wouldn't be here. Because I accept that the public interest will outweigh all the commercial damage that will be done by taking that unsafe product off the market, that dangerous product off the market. I freely accept that. I freely accept that in a judicial review, American Sign-O-Mead test, if the public body can show a weighty public interest, it will be the trump card, or 9 times out of 10.
So it's not an. So you say it's not an unvarnished American Sign-O-Mead.
No. I think I said American Sign-O-Mead plus. I mean,
Yes.
there are lots of other, like the adequacy of damages is not usually an issue, and there are other modifications.
So the public law, as it were, the public law element comes in at an initial stage, on the question of arguability, and the like, and it's the public interest which comes in at the second stage of balancing convenience, for want of a better expression.
It's a curious submission, really, that if BSI consider, in all good conscience, etc., that the evidence is no longer sufficient, the court is now powerless to grant an injunction. That appears to be where you end up with my learned friend's submission. There's a sort of BSI or regulator immunity from injunction, because if they form the view that the statutory tests are not met, the court is sort of bound by that at the American Sign-O-Mead stage. The court may later find, of course, on the actual substantive JR that they were wrong, they were irrational, or they took into account the wrong factors or natural justice or whatever. But American Sign-O-Mead cannot be, American Sign-O-Mead plus the public law authorities, cannot be hidebound in that fashion. And what Mrs. Justice Laing did was to take into account the practical situation. She also took into account that my learned friend next to me is waiting to catch the ball in the event that the statutory powers that his client has are engaged, because there is a risk to health and safety. He can issue a suspension notice under his client's act, and I have to go to the magistrate's court to appeal it. And she acknowledges that public safety failsafe. She says, don't do it just because I've issued an injunction, but of course if you've got proper grounds to do it, because this product does pose a risk to health and safety, which is the statutory test under the 2021 Act, then you'll act. Or come back to me or whatever.
So what you're saying is that if we had a product that is in no sense dangerous, but just it hasn't been demonstrated that it works, but that doesn't mean it'll harm anybody, you say BSI can't simply say, well, they've failed to satisfy us that it works, ergo the court can't do anything about it.
Or actually, in this case, it's in an unlawful manner, we say, it's had its equivalent stool kicked away. And it's going to fall over because it doesn't have clinical data yet. Because it's innovative, new, and it was relying on the Philips heart start. So,
and presumably, I mean, there's 2 ways you could answer that. One is to produce the clinical data, which I understand will take more than 90 days. But the other is to say, no, they are equivalent, and here's why.
Yeah. Well, first of all, the clinical data is on its way. It's not that my client doesn't want to keep relying on somebody else's product. He does have clinical studies underway. Very recently, you'll have seen from I think what Mr. Johnson, my own friend Mr. Johnson referred to as the sort of recent fracas with the MHRA. You'll notice that the MHRA sought our clinical data and our reports about serious adverse events and so forth after the injunction. And we provided all of that. And we've not been served with a notice. We have been served with a request for a voluntary suspension that we don't need to get into before this court. But that is a sign that there's not anything of great weight or mass on those public interest side of the scales. apart from we kicked away equivalence, and therefore there's insufficient evidence to satisfy us that you meet the essential requirements.
I mean, assume you're right, and that it is a broader, more modified, American cyanamid balance of convenience type exercise. Why can't the regulator say, look, there are on the market a whole host of defibrillators, 9 of which, let's say, 10 of which satisfy the essential requirements. It's been demonstrated to us. And 1 of which it has not been demonstrated to us satisfies the essential requirements. It's in the interest of public health and safety that the public should buy 1 of the 9, not risk buying the one which hasn't been demonstrated to us to work.
Well, in all frankness, that's the highest you can put it. And then you put that on the scales, you look at the commercial damage to my client in circumstances where it does have a strong JR claim, or at least a serious issue to be tried, and the judge weighed that up and came down in the exercise of her discretion in our favour. I do take slight issue with treating a defibrillator a bit like all the many different brands of aspirin on the Boots counter, because if you need a defibrillator, you're not going to get a choice. You can't say, I don't fancy that one.
No, but
I'll have another one.
But the choice that was identified by Mr. Johnson is the choice at the point of purchase.
Yes.
It's not. It's
I'm not cavilling. I'm saying that's his public safety case at its highest.
Yes, but he says it's not a question of people, as it were, picking and choosing between defibrillators when there's a non-breathing person lying on the ground.
No.
It's if I want to buy a defibrillator now, I shouldn't be able to buy one which hasn't proved its worth to their certification standards, as opposed to the ones that have.
Yeah, but that doesn't, in my submission, create a degree of weight. Well, in my submission, Mrs. Justice Laing was entitled to find that didn't create a degree of weight that meant that it displaced the commercial damage to my client. I mean, that's the balance she's striking. And when she says there's no evidence of risk to public safety, she's not getting the directive wrong. She's not getting the regulations wrong. She's not making this error of law that my learned friend refers to. She's just saying, no one's come before me and said it's a danger to the public in the real sense. It's just that the data before the BSI is no longer sufficient. The BSI no longer satisfied that there's enough data that it may well be effective. It may well perform as described because they were relying on the Philips product. And the question that the court asked itself is that enough? And it's not in the learned judge's decision. But I don't think that can be characterised as an error of law in the way that it's been. That's what I mean. I think it's a category error. She's not hidebound by only one concept of public safety. And the BSI go further. She's got to be hours, and hours alone. And American Sodomy cannot be that narrow, or American Sodomy plus, as the judge recites in her judgment, plus its modifications. My second and other point broad point on ground 1 is that the failure to satisfy sufficiently is the sting and gist of the JR. So my learned friend is seeking to rely on the very thing that we are alleging is unlawful. The breach of natural justice, the reliance on unverified, unpeer-reviewed guidance, the failure to talk to us, quite frankly, about our product and how it works and to properly understand it. Even to this day, and you can tell from my learned friend's skeleton, there is a lack of understanding about how our product works, about how they're still saying it doesn't have enough energy, doesn't comply with the UK Resuscitation Council guidelines on energy, which themselves say this is based on how the industry works rather than on peer-reviewed science. But it's akin to saying we've got ourselves into this position of kicking away the equivalence stool. And we say, but yes, we know, but you've got there in an unlawful manner. But it just means that BSI win the injunction application. That can't be how the equitable jurisdiction works. That's that's deferring far too far to the public body. Now, of course, in Ofsted cases, in housing cases, in the many cases where there is a body saying, please, please don't go public with this, it will ruin our reputations, it will ruin our lives, there is a heavy public interest that the public body always relies on. And my learned friend is entitled to rely on the public interest in his client's function and its decision. But then it goes on the scales. And then it has to be weighed. On my learned friend's submissions, you don't need a pair of scales. Because it's always going to be the trump card. And that cannot be how the law, it isn't how the law operates in this area. The law operates as my Lord Justice Snowden has described in terms of how the American Sinamede test generally works, even when modified. So when you look at the judgment, that's precisely what is going on. Now we have a debate about how serious issue and how the test works. Now there was a clear concession below. In fact, you see the concession, the reasons for refusing permission to appeal. Mrs. Justice Laing highlights it. You see it in the transcript. It's not demurred from today. That we were fine on the first stage. We had
there is a serious issue to be tried.
There's a serious issue to be tried.
It's not been stressed.
And we agree that you can bring back in strength of the claim into balance of convenience. But we say that a fair reading of this judgment is what is going on.
But where does the judge evaluate the strength of the legal case? All she says is there's a serious question to be tried. Some of the claimants' points are stronger than others.
Yes, and we say that is her assessing the strength of the claim.
Does that go far enough?
Well, as she actually explains in her reasons for permission to appeal, the reason why she didn't analyse the grounds any further, she says, was because she had the concession. And she says, at page 83, I was able, in light of the defendant's concession, I was able to deal with the grounds relatively briefly. Whilst accepting that some grounds stronger than others, I was satisfied that the serious issue question to be tried. The contentious issue was the balance of convenience, then on she goes. So I think it's a little unfair to say that she had not assessed the strength and was satisfied as to the strength of the claim. It's unfair to say, well, because she didn't do the tick box exercise that Lord Hoffman decries and say, you use the formula of words that my learned friend is looking for, to say that she wasn't cognizant about the strength of the claim. I mean, all it's really saying is, well, the content of paragraph 20 might have been better drafted into 21 and 22 in an extempore judgment.
What I'm asking you is a slightly different point. Maybe I didn't put it clearly enough. Is it enough for there to be a serious issue to be tried in this context, or do you need a stronger case?
You need to weigh up the strength of the claim and how strong it is as part of the factors under American Sinamede. I do disagree with what my learned friend is saying under ground 2. I don't think there is a separate test for mandatory injunctions. But I would accept that if you're seeking a mandatory injunction, strength will also be very important. But it's not a threshold or some other special test. It is all part of the factors that you're weighing up.
But I think, as I understand what Milady's putting to you, is that yes, you get over the threshold issue because there's a serious issue to be tried.
Yeah.
I.e., that the public body,
Yes.
Unusually the public body
Yeah.
has arguably failed to discharge its functions properly,
Yes.
and therefore is amenable to judicial review. But because you are granting an injunction, or considering whether to grant an injunction against a public body performing public functions, you at the second stage, I think accepted a moment ago,
Yes.
that you bring back in
Yes.
the strength of the case
Yeah.
as a potential.
Yeah, and I
factor
conceded
in
that
balance.
below.
And I think my lady's putting to you, did the judge actually do that?
I can't put words into the bit of the judgment where she's dealing with expressly balanced convenience, but read as a whole and with her reasons for refusing permission to appeal, I think we can be confident that she took into account the strength of the claim overall when deciding the application.
But on her express reasoning, it's a claim. The strength of the claim gets no further than showing that there's a serious question to be tried.
Well, in fairness, 19 is I've got a concession, so she could have stopped. But in 20, she goes on to say, I have carefully considered the defence evidence its submissions. While some of the claimants' points are stronger than others, I'm satisfied.
And I understand that, but
Yeah.
you're not really engaging with the question I'm asking, which is there any suggestion that she got any further with her evaluation of the strength of the case than to decide that there was a serious question to be tried?
No, her language is what language is. She
Yeah.
doesn't. Yeah, I can't pretend otherwise. But I'm not sure it follows that there is some box ticking exercise. There is some threshold, some formula she has to recite, that a judge has to recite.
It's not to do with reciting formulas, it's to do with the substance of the judge's reasoning.
Yeah, and the judge well had in mind the strength of the claim.
She just hasn't told us anything more than that there's a serious question to be tried.
Yeah, and the gloss that claimant's points are stronger than others, and I take it, I do accept that could be taken one of two ways.
Well, that doesn't take it any further, does it?
No, really.
No, all right.
But that is then, if you look at paragraph 21, we are then in the balancing territory, because on the other side, she's looking at the commercial and reputational harm. Then she's looking at if BSI restrain and so forth. Then we're into public health and safety. So there may not be some subheadings. I'm now on balance of convenience, and it may all be running together. But as we know, it's not to be construed in the statute, and the usual allowances are to be made. And we can see, I think, from the reaction to the permission to appeal application, what the reality of the situation is.
And it's curious that having reminded herself at the end of paragraph 17 that the strength or weakness of the claim is likely to be a significant factor in
Yes.
assessing the balance of convenience, which is a sort of paraphrase of what was said by Lord Justice Lindblom in Governing Body of X.
Yes.
I.e., he said, the underlying strength of the substantive challenge is likely to be a significant factor in the balance of considerations weighing for and against the granting of an injunction. That's, I think, the same, he's making slightly different language, but the same basic point of the test.
Yes.
And having reminded herself of that, she doesn't then go on to say, do I think this is actually, given that it's a public body, a stronger or a weaker case?
Or reminds herself and is taking it.
Then doesn't tell us how.
Well, as I say, there aren't any subheadings. It all runs together. Balance of convenience, I mean, where does it start, where does it end? You can see by 20 she's talking about, 21 she's talking about considerable commercial and reputational harm.
I think you can identify where balance of convenience starts because she says so at the end of 20.
Yes,
I turn to consider.
Yeah, but I could be. I turn to consider having assessed the strength of the claim. Yeah. I'm not sure we can. Yeah, I'm not. You know, we have to make the usual allowances, and not read it like a statute. English and Emery, on all cases passing. And in English and Emery, if there's a problem with the reasons, you can take into account the permission to appeal reasons. And it all needs to be taken together. And we decry box ticking. And it's we decry box ticking, which has got us where we are now on ground 2, that we have moved on. There's no need for an extra threshold for mandatory injunctions. Now, turning to the mandatory injunction,
Can we?
Yeah.
I mean, there is a question of law as to whether we are bound by what this court said in Crawley and DeFalco, or whatever it's called.
Falco.
Yes. And I think you say that we can depart from that. DeFalco and Crawley, it's a decision of Lord Denning and two of his colleagues. And he says that it's not just a straightforward American cyanamide, and there is a different way to. 478. This is not the same sort of case as American cyanamide.
Yes.
No injunction should be granted unless the plaintiffs make out a strong prima facie case.
Yes.
And I think Lord Justice Bridge says much the same. Now, can we say, oh well, things have changed in the last however many years it is, 44 years?
Well, I've given you a quotation from a position decision decided by Lord Justice Hickinbottom at paragraph 17 of our skeleton.
Yeah.
But I can't use that for obvious reasons because it's a permission decision. But I think I do use it to adopt that reasoning as to why things have changed. And I also take you to other cases at paragraphs 18 and 19, which are not in the JR context. But as I say, you've got Lord Hoffman warning against those sorts of box-ticking, threshold type tests, particularly for mandatory injunction. And for those reasons, whilst there may be, you can see there are context-specific situations where, for example, you are ordering a local authority to rearrange its scarce resources to provide housing. You are ordering Ofsted not to produce a report that parents and the public want to read. All these factors are likely to have an effect, a significant effect on the balance of convenience. But they shouldn't amount to some new threshold.
Can I ask you, Mr. Heatherstall, something I asked Mr. Johnson about? Can you tell us of any case in the public law field where a court has upheld a decision to grant a mandatory injunction in relation to a decision which has not yet been made, and therefore it follows a decision, the lawfulness of which has not been decided one way or the other?
I can't find an example, my lady.
No, so
but I will.
This is completely new ground, isn't it?
But I will say this, that on the night before, well, let me take it slightly slower than that. Let me show you a couple of things before we get into, which involves reminding myself where they are. So let's go back to the supplementary volume, and let's look at paragraph 8, page 344. And this is the second statement of Mr. Tunbridge, and this was paragraph 8 at page 344 on the 20th of March at very late in the day.
So just let me get there. Yeah.
So page 344, in comes the news, and it's news to us, that BSI is not obliged to renew a UK CA certificate, nor would it be able to do so in the present circumstances in light of the identified non-conformities which remain unaddressed.
Yeah.
So in other words, when the affluction of time comes, we won't be renewing because of the kicking away of the equivalence stall.
Well, that's not quite what he's saying. He's saying nor would it be able to do so in the present circumstances.
Yeah, in light of the identified non-conformities.
You can't preempt what the situation may be when the certificate actually expires. We simply don't know what would happen when the certificate expired.
Well, he's saying that in light of the identified non-conformities, it's not going to be renewed. So,
But he says in the present circumstances. So if you came up with some answers to the questions, it may be that it might be renewed.
but that's utterly unreal, my lady. The idea that we are going to recreate the clinical evidence required when we've been relying on another product. The idea that our clinical studies using students and so forth, which are all, of course, blind and independent to us and can't be rushed by us because we can't have any influence over them to make them scientifically legitimate. The idea that that would be done by May is ludicrous. It's wrong, actually, for my learned friend to say that we didn't supply a cap. We supplied a cap on things that we could realistically do in the time available. But there's only so much one can possibly do. So there is not, with respect, my lady, if you're saying that my client can produce a clinical study.
I'm not saying anything.
No. Well, I know, my lady, but the idea that the circumstances are going to change is not a available logical proposition. The circumstances are not going to change until we either win the equivalence battle, which is a battle which has to be done between scientists and technicians and experts who can argue to the heart's content over the equivalence guidelines which are addressed to such people, or we lose that battle and we have to get clinical evidence or bring our studies somehow to fruition without interfering with them.
I wasn't quite clear that that was the battle you were going to have in June or July on the substantive hearing of a JR, because we were told that expert evidence wasn't going to be available for that. The JR is presumably about the procedure by which
Procedure?
the BSI went about its
Yes.
reassessment.
Yes. I don't know whether my lord has seen that actually our preference is to get into a confidential arbitration where you could have findings of fact made and expert.
I don't think I had to pick that up.
Well, that's what we really want. We can't have it because it takes two to tango in an arbitration. In default of that, we have our JR. That, as I'm sure you know, there is a very clear limit to which expert evidence can be deployed in a JR.
Yes,
it can only be deployed to background.
What is the relief you get in the JR if you're successful is you quash the decisions. Do you also get a mandatory order that the certificate be kept, be renewed?
The court has all of its options, but I'm realistic and I am fearful in terms of costs that we may just go back round the loop.
Well, that's what I was wondering, because normally, if a decision has been made unlawfully because of procedural impropriety or irrationality or whatever, all the court does is send it back to a decision-making body to make a proper decision.
No.
That doesn't give you a certificate.
No. So, hence why we were trying to persuade the parties to my left. And I think it's right to say that we are making progress with the MHRA in our confidential negotiations with them. That what we need are the relevant experts to deal with this issue.
Somebody has to address the question of whether it's equivalent or not.
Yes. Yeah.
But that doesn't seem to be a matter for the JR.
Well, in the JR, there is a ground, which is that the decision that it wasn't equivalent was irrational.
Yes, I see. But in the absence of expert evidence, it might be difficult to establish.
Well,
but I'm not going to tell you how to run your case.
No, but my lord is describing the dilemma. Yes. We are fully alive to it.
So,
and Mrs. Justice Laing said that some grounds are stronger than others.
But suppose you were to get to July and succeed in showing that decisions had been made in breach of public law requirements, and therefore they're quashed, because that's the normal relief granted where a decision's been made improperly. How realistic is it to think you'll emerge from that with some mandatory order requiring the certificate to be kept in force pending it being done properly? Because my follow-on question, you can anticipate, is if you're not very likely to get that at a final hearing, Isn't it quite an odd thing to do it at an interlocutory stage?
Well, forgive me. I thought Mother was referring to a permanent mandatory injunction. I would certainly expect to have an interim, further continuation of the
interim mandatory injunction until the decision can be made properly.
Yes, yeah. Otherwise, it's all pointless. And we would hope that the judgment would be in our favour, be critical of the BSI's procedure. It would give them a clear steer that next time round they should sit down with their scientists should sit down with our scientists.
Yes.
And we therefore the decision that comes out of it at least has the benefit of our scientific input.
If your certificate just expired through effluxion of time, in the current situation, on what basis can you require the BSI to grant you a new certificate?
Well,
before they've had a chance to actually to answer the question for themselves.
Well, that's the problem. He's answered it already. He's come what may. We're not getting a certificate.
Well, he doesn't say come what may, because he just says in light of the identified non-conformities which remain unaddressed.
Yes, but I think that's my rather impertinent response to my lady, which is, in the current circumstances, they won't be addressed anytime soon. This is why my client is finding the current circumstances difficult to deal with and grapple with, because it's one thing to say.
But if you could show, I mean, this is why I was trying earlier to identify whether the equivalence is a technical equivalence of the product or a clinical equivalence of the effect. It's because I think your product is technically different. You can't claim, as it were, technical equivalence because it works differently.
Yeah, but that's always the case. That's not, well, no, it's not always. It's often the case. With innovative products, I meant to say that's always the case. Right. Sorry, with that gloss.
Yeah.
But equivalence can work. In fact, equivalence is designed as a matter of policy to get innovative products on the market whilst they accrue their clinical data. Because they don't have clinical data because they're new. So you use equivalence to get them onto the market. You say, I'm like this one.
Technically like this one.
Well, there's a whole range of guidance that you take into account on equivalence. Our case is it's equivalent because it does the same clinically significant job. It has the same clinically significant method of getting to the correct rhythm on the heart.
Yeah, but that's...
Yeah, but that's
the point of difference between...
That's what I'd like experts to slog out over in an arbitration or some other form of dialogue that I'm hoping someone will indulge my client in. So that's the practical reality of the situation. So going right back, it is a mandatory injunction, but is it not a mandatory injunction in aid of the prohibitory injunction? I mean, that's what the learned judge below says. I will make it a prohibitory injunction in vain because the very thing that I'm making the prohibitory injunction against, keeping the status quo as it is because of this judicial review claim and its grounds, is just going to be defeated by the effluxion of time and by this decision that because of that same kicking away of equivalence, these non-conformities mentioned in paragraph 8, the claimant will just be in the same position. So it's a mandatory injunction to keep on holding on to the ring, to keep the status quo in place. So I do not shy away from what my Lady Justice Elizabeth Laing is putting to me, that it is novel, it is different, but it is a proper judicial reaction to the circumstances that the learned judge found herself in.
Do you accept it's a species of what my lady called quiet time it, saying unless something is done, you're going to make a decision. That will be an unlawful one, so we can stop you
Say for my forceful submission that the decision's more or less already been made.
Yes, I see.
Yeah. So, not quite queer, not quite timid, because this claim is, the reason why this came as quite a shock to my client, and if you look at supplementary 254, and I know that my learned friend says he's troubled by what we're saying about this, but at the same time as this is all going on, there are auditors in Australia, BSI auditors, clearing us for renewal. And if you look at what is said to us at 254, as a result of the visit and the accepted correction plan, 8th of March, I'm able to make a recommendation for recertification.
Well, he said that's just QMS.
It is just QMS, but then it's interesting that somebody signs a written statement saying, come what may know.
Yes.
Sorry, can you give me the bundle reference, please, Mr.
254.
254, thank you.
So, I mean, another point my other friend takes, and I can't shy away from it, is we didn't apply for mandatory injunction because it's only the night before that this lands. In circumstances where my client's thinking, well, this is interesting. We seem to have a very Janus-faced BSI. One of it's been very aggressive to us, another one's writing us letters saying we will recommend recertification. We'll see how that plays out. And then we're told, despite that recommendation about your QMS and about your manufacturing systems on the ground in Australia, then the no equivalence decision means that it doesn't matter. And the judge, in the time available, is saying, what's the point of me making the injunction to hold the status quo in light of this claim and to save your client from the commercial peril, if in fact, in May, and we haven't got the JR on by May, it's all gone away. So yes, it's novel, but it's entirely appropriate. Otherwise, the court is powerless to deal with what's said at paragraph 8. Again, BSR play a trump card and the court goes, oh, right, fine. I was going to make an injunction, but I'm not now. That can't be. The court cannot be tied up in that way by one of the parties.
If you're just this is a hypothetical question. If your certificate just had not been suspended and had just expired and not been renewed, you wouldn't be able to rush off to court and say, I want a mandatory injunction requiring BSI to give me a new certificate, could you?
No, but we would require a decision. And if we got a decision that said, let's imagine that this technical review never happened. Let's imagine that the equivalence decision was made on the renewal. If we would have given notice of it, I might go to court and get an injunction if the procedure was as bad as it was and I alleged before. But the reflection of time is never really just going to happen. I want my product to be on the market. I want to sell it. So I'm always going to say, renew it, inspect my premises, look at my technical file and give me a new certificate. I want a new one. I want to sell the product in the UK with a UKCA certificate, not just a CE.
You presumably knew that your existing certificate was coming to an end.
Yeah, that's why there were people at enormous expense in Australia poking around doing their audit.
Yeah.
Of course. We don't want it to expire. We wouldn't be spending lots of money on me if we don't want the certificate. I do urge the court to look at the practical commercial realities in the strictures of public law, of course. And I ask you to see that that's just what Mrs. Justice Laing was doing. And she was a classic exercise of discretion. It's ring-fenced ambit of reasonable disagreement. Mr. Justice Saini, police the perimeter. That's all this court does. Doesn't get inside the perimeter. And there is no reason to get inside the perimeter in this case. There is no countervailing public interest argument that displaces the commercial peril that my client will be in if its product has to doesn't have this certificate for sale in this country. It will affect its global sales. It's not just about sales in the United, or I should say Great Britain, for the reasons given by other for Northern Ireland now, doesn't have the benefit of the same regime. Or has the benefit of another regime, I should say.
This may not be the appropriate place to put it, but what do you say about the lens through which Mr. Johnson says we have to look at public safety? And I picked a number of times at that point. Is it a question, is there a balance potentially between dangerous items that actually, if used, can harm, affirmatively, positively harm, and items that just won't work as intended?
Yeah,
or do we look at public safety simply through the lens that there shouldn't be out there products which promise more than they can deliver in the public health and safety arena?
Annex 1, wherever I put it, Annex 1 of the directive has all the penumbra of considerations that all go towards that risk-benefit balance. One of them includes, it always includes in all of these regimes, if I make a claim as to performance, it must meet that claim. So it must work as the manufacturer intended. So that's one of the things that goes towards the benefit bit of the risk-benefit analysis. That little paragraph 6 says you can even get away with it doing that, even though it has bad side effects, if the balance is still positive. So all that is baked into the classic European law public safety test that we still use even post-Brexit. So where we depart, I don't depart from the description of the statutory regime at all. I'm just saying that Mrs. Justice Laing's not hidebound by it. She's entitled to take a real-world, practical approach to, is it actually going to hurt people? Is it sparking? Is it exploding? She also, if you note in the judgment, accepts my submission that it's actually life-saving.
But it was that latter point that I had in mind. I mean, if there are other devices out there which have satisfied the BSA, are effective to the correct to the whatever the required standard is, why should they be able to buy yours which hasn't satisfied that required standard in their judgment in the meantime? Because that could be the difference between life and death for somebody if they're using your product rather than somebody else's.
My clients' instructions, which are coming through to me as they watch it in goodness knows what time, in real time on YouTube in Australia, is it is saving lives. People's lives have been saved, but you don't have evidence of that. If someone has bought this product and that's all that is to hand, and it can help save someone's life, as we say it would, then if it's available, they should use it.
If somebody has bought it, in a sense, the bird has flown. I mean, that's not. Mr. Johnson very clearly made that point to me when I sort of put that to it.
Yeah.
He said it's not a question of recalling these devices that are in the hands of people.
Yeah.
I.e. members of the public, people who bought them. It's a question of a member of the public or somebody looking to buy either that product or another defibrillator, which has satisfied the certification requirements.
Well, let's remember the journey we've been on. They're saying they don't have sufficient evidence. When they accepted it did, I showed you the email, they accepted the heart-start equivalence data. It worked and had the same effect, and that was equivalent. And all that's changed is not reports coming in to regulators that it doesn't work, or evidence from users reporting into the MHRA or other regulators. All that's happened is that they've taken away that equivalence stool such that they can no longer be satisfied. That's the situation we are in.
Yeah, but that's because somebody has taken the point, which they may not have taken before, that it works in a different way.
Yeah, but that doesn't amount to positive evidence that it doesn't work at all.
Nobody's suggesting that there is.
Yeah.
I'm putting to you the proposition, which I thought was Mr. Johnson's, where he'd ended up in the debate with me, which is that because it's not the only defibrillator on the market, if it hasn't satisfied the certification requirements,
Yeah. Well, I think I conceded before
why,
that
why shouldn't the public be
that's his
able to
public
buy?
interest argument at its height. I'm not saying he can't make it, I'm just saying it's insufficient. That's his public interest argument at its height. I recognise that. But Mrs. Justice Laing is entitled to put that on the scales and weigh it. But it's not the same as something that would tip the scales in my submission, which is it doesn't work, or it's unsafe, or it's exploding. The school is unsatisfactory in Ofsted's view. It went to visit it, found it unsatisfactory, that should be published. My client's homeless. He should be housed, there's been an egregious public law mistake. These are all the classic exercises of discretion on the rare occasion where you need an interim injunction in a public law case. And everything should be on the scales. But the scales shouldn't be tucked away in the straitjacket of the directive and the MDR. That's where the category error is being made. Ground 3, that is a well-patrolled and protected perimeter surrounding the discretion and costs. I would just draw your attention to something I drew to Mrs. Justice Lang's attention, that we did our utmost to avoid making the application. The relevant emails are at pages 49 to 54 of the supplementary bundle. We didn't understand what the rush to suspenders was, and we sought to slow that down as much as we could. We begged and craved to the BSI to slow that down. We didn't achieve that, and we were forced to get the injunction.
But would you accept that it's unusual for a judge to make a costs order in relation to an application for interim relief when the substantive merits are still up in the air and are going to be decided relatively quickly at a substantive hearing?
I accept that that is a available alternative exercise of the discretion that is commonly done.
Sorry, that wasn't my question. I didn't say was that an available alternative. What I asked you was, is it unusual for a judge in those circumstances to order the cost of the interim relief application?
I accept. However,
the defendant.
Yeah, but available and proper exercise of discretion in these circumstances where BSI, given everything that I've just submitted, should not be in a rush to chase us off the market.
But what explanation did the judge give for I just want to focus on this question. What explanation did the judge give for taking that unusual course?
Oh, sorry, I missed that last.
Sorry,
Apologies.
what explanation did the judge give for taking that unusual course on cost?
I think we only have a note, I think. Is that right, of what the judge said on costs? I'll be correct if I'm wrong.
Somewhere there's a transcript of the proceedings. I don't know whether that's where one sees everything on cost.
Yes, I think that at page 80, there's an agreed note of costs and permission to appeal judgment.
Right.
But I don't think, despite there being a gap in the transcript of proceedings to allow for the transcription of the judgment on costs, I'm not sure we do have that. Somebody will correct me if I'm wrong. No, we don't.
So we don't know what reason she had for
Well, we have the party's note.
Right. What does that say?
by the whole second whole bunch on page
Yes,
81.
page 81.
Right.
I think.
Lily, it insists the paragraph that begins, I'm just going to indicate
Yes.
my decision on the cost.
Yeah, and its defendant has forced claimant to come to court to obtain interim relief, to which I found is entitled. D could have agreed interim relief of this nature and must take the cost consequences.
Is there any difference in practice on this aspect in public law cases from private law cases? Because I think it's quite well established in private law cases that the norm for an American cyanamide type injunction is you don't decide costs at that stage. I mean, obviously you can depart from it if someone's behaved utterly unreasonably or the like, but standard practice is, since you're not deciding the merits and it may turn out the claimant wasn't entitled to any relief at all, you send it off to trial. Is it different in public law cases, or?
I think my answer to my Lady Justice Laing.
It is really the
same
same
answer. I can't.
You
I
can't say there's some special rule in public law cases. No.
But I can say it's discretion, and I can say it was exercised in this case.
Yes. Thank you.
Those are the respondents' solutions.
Yes, Mr. Leary.
My lords, my lady, the MHRA is grateful for the opportunity to make what I hope will be very short submissions. You will have seen from our submissions below that partly because it goes to the balance of convenience, we addressed the ladyship on the MHRA's regulatory position at the time, and we have updated that position before you so that you have the current position before you. We are here as an interested party. There's no decision of the MHRA under challenge. The injunction's not made against us. So I have little to say, save that the MHRA shares the BSI's concerns about the effectiveness and safety of the product. And it's important in our submission to recognise that the effectiveness of a product does go to its safety in certain contexts, particularly in a medical device context such as this one. And that could be treated as separate to the danger posed by the inherent danger of the product, by which I mean, if you have an inflatable paddling pool that doesn't inflate, it is ineffective, but there's no obvious unsafety that arises. If you have an inflatable life raft on a vessel that is ineffective because it doesn't inflate properly, that poses fairly obvious safety concerns. And it's the point that my lord made about alternative products, and we know that the Philips Heart Start is at least another portable defibrillator that one could use. It may not be quite as small, but it is claimed to be an equivalent product. It's also admitted to be a portable product. My understanding is that there are others. So the point is that you could buy this device, it could prove ineffective, and that's a danger or a public health concern because there are other proven devices that you could use instead. So the MHRA is actively investigating this, and as my learned friend alluded to, has requested now a voluntary suspension of sale of the device, pending the resolution of these proceedings and the satisfaction of the MHRA, either of equivalence or of the safety and effectiveness of the device. The MHRA hasn't formally exercised powers under the Medicines and Medical Devices Act 2021 yet, for example, by making that request mandatory.
Can I just go back, state what may be obvious? There's a strange debate about what equivalence means in this case.
There is.
I thought the basis for the withdrawal of certification is that there is no equivalence between the cell AED and other defibrillators on the market.
That's right, my lord. I mean, it's really a question for the BSI's and its reasoning, but my understanding is that is the primary basis on which certification is.
So there are other defibrillators which can be purchased, which have met the appropriate efficiency, efficacy standards, essential requirements.
That's right.
But they're not said to be equivalent to the cell AED device anymore.
That's right, my lord.
So I just was trying to, when you were saying it depends on the availability of alternative products, and equivalent products, I think we've got to be careful what how we put it.
Yeah, I apologise if my language was imprecise. Perhaps I should say competitor products would be a better.
There are other defibrillators available.
Because other ones that you might purchase on the market. The question of whether they are...
Including at least one portable one. I think
Correct.
that's not in dispute.
Correct, my lord. But of course the question of equivalence is different, and,
Yes.
and we're then into the debate about whether it's energy or charge. The short point there is, my understanding is, and it's actually set out in the defendant's witness evidence, although the wrong parts are highlighted, but the UK and the EU guidance typically prescribes an energy range for a defibrillator. I think it's 150 joules up to, I think one of them is 180, one of them is 360 joules. My understanding is that's because that's a reliable guide within that range of whether you will achieve the charge across the heart that you're looking for. And so when someone comes along with a new product and says...
Sorry, well, you achieve, it's not the charge, it's whether you will achieve...
It's the current, sorry, I've confused myself. It's the currents across the heart that you're clinically looking for. And the energy band is a reliable means of testing whether that will be accurately achieved and reliably achieved. So from a guidance perspective, although what you're ultimately looking for is currents across the heart, what you are looking for in terms of equivalence, at the moment at least, is charge.
That assumes that that the two devices work in a similar way.
Yes, and so when you have a device that's novel, that doesn't fit the mould and therefore doesn't come within the range at all, you can understand why a regulator might ask further questions about whether the claimed charge across the claimed current across the heart is right, and if it's reliable. Now, it may be in time that charge, that dual-based range will be expanded.
Yeah, and you say it's for the regulator or its delegate, if you like, to be satisfied by the manufacturer of that. That's where the burden lies.
Precisely.
Yeah.
There's been, in writing at least, some criticism of the MHRA. It hasn't been repeated orally. I've addressed it in my skeleton. I don't propose to say more about that because it would generate rather more heat than light. But unless I can assist you further, that's all I wanted to say from the MHRA.
Thank you very much, Mr. Yes, Mr. Johnson.
Well, as I'm conscious that you had a lot from this morning and want to attempt to be brief.
You don't need to repeat anything.
No, indeed. Well, I'll avoid doing so if I can. A few small factual points that have been clarified this afternoon. Firstly, I think it's agreed from what we've heard in submissions that there are other devices that are portable devices.
There is at least one called a Philips Heartbeat, I think, which is 1.5 kilos as a Heart Start.
Whether that's a misnomer or not is a question that may be beyond us for today. I understood my learned friend to say that there were others, but in any event, I don't take any point on that. But I think portability on the shelf as regards selecting between devices, which is a question I was asked about earlier, I think is agreed, and that's a helpful ground clearing point. A small point
I can see that a 300 gram one might be a great deal more convenient for a lot of people than a 1.5 kilo one.
Well, my lord, I'm not going to...
And quite a bit cheaper.
And no doubt cheaper. Well, we haven't. I don't think we've got any evidence as to price. But yes.
I'm not going to...
You have what you have.
Indeed, my lord, and I don't think I need any more for the purposes of the submission. You understand the thrust of the submission. I won't repeat it. A second small point of fact, just to pause on for a moment. I think it was suggested, but it may have been suggested, in error of no criticism is made if so, that my client would have a duty to notify equivalent certifying bodies overseas. My client's understanding, and I have taken instructions, that it doesn't have that obligation. I'm very happy to be corrected, most happy to tell if I'm wrong, but I don't think when my client suspends or doesn't certify, it then has to write to every other regulator worldwide and tell them you certify this device, and therefore you should be aware that we haven't. If Mr. Hempstead can correct me, I'd be content to be corrected, but I've taken instructions.
Yes, let me correct that. I think the chain of events would actually be, I think the statutory duties on, as you'd expect BSI to notify the MHRA.
Yes.
I think there's then probably a duty on us as the regulatee to inform our other regulators what's happened in the United Kingdom. But the news would be out.
That's my understanding. It was a very small point, but I did take instructions and I wanted to clarify it for the sake of precision. A third, really quite small point. I understood my learned friend saying at one point that if the certificate was suspended in the UK, then his client would stop selling elsewhere. And that isn't quite what the evidence says. The evidence says that it would have an impact on sales elsewhere. That's in Supplementary 7, page 92. I won't turn it up, but to the extent that the submission was that there would be a cessation of other sales, in the sense that, well, we can't possibly carry on selling if the UK BSI has said no, that isn't what the evidence says. The evidence says, look, this is going to have a knock-on consequence. We've always accepted that, but I just wanted to clarify that and lend it precision. Third point, equivalence, and we've reverted back to the topic of equivalence this afternoon. My learned friend says we've kicked the stall of equivalence away. Just one thing to draw out and shine a brief lantern on. There are two options open to RRR. One is to go away and gather all of the clinical data that underpins the heart start. But there is another option, and that is...
Sorry, it can't guarantee... Sorry, why could it gather all the clinical data that underpins the heart start if you've said that it's not technically equivalent?
So
it won't help it.
I've been too glib and too quick. Well, I should slow down. There are two options available. One is to say, here is a body of clinical data which demonstrates that our device is safe and effective and meets all of the requirements. So they could go and they could conduct the clinical studies to show, irrespective of any other device, ours works.
Well, they're going to have to, because if they're right that theirs operates in a different way, by definition there won't be effectively clinical data out there showing from other manufacturers that they could gather, because the tests won't have been done. That's, I think, Mr. Hebenstall's point. They're going to have to start themselves to get their own clinical data using their own product, which, if you're right, isn't technically equivalent, technically the same. They've got to do from scratch.
Well, there is another body of evidence that they can rely on to persuade my
But I'm right about that, aren't I? Well, he was right about that.
He's right that if he can't persuade my client as to equivalence, or if there is no case as regards equivalence, then yes, it's right, he has to go away and gather that body of clinical data. The other option is to meet my client's concern as regards equivalence with data. So that's the other data gap they can fill. If they are able to say, yes, it is different, it operates in a different way, but let us show by data, by studies, that this is operating in the same way, it's producing the same clinical results, then that's another route. And so I just wanted to draw out those 2 points. If Mr. Hempstead's point is, well, it's different, and so therefore we're forced to go and gather data, well, that's the nature of the difficult position with respect his client puts itself in, when it simultaneously announces, A, we're innovative and we do it differently, B, we're equivalent.
Well, I think he has an answer to that. I mean, we're not going to decide these points, but
No.
I think his point is, what matters from the point of view of the patient is the amount of current. And although we have much lower energy because we do it differently, we don't have a 70%, 30%, we have lots of capacitors, we do the 50%, 50%. It produces exactly the same current, and that's what's clinically significant. Now, if he can satisfy you with that, that's all he needs to do.
And that's the submission
And
that
that is his case. I mean, that is his factual case, as I understand it. And I think you're not yet satisfied of it.
No, we're not.
You say you're not yet satisfied.
We don't. Yes, we don't just say we're not satisfied. We're not satisfied, my lord, as to that point. The point I'm making is that to the extent that Mr. Heppenstall is saying, well, there's this huge body of research, we're going to have to go back to the beginning we're going to have to go back right.
Well,
to
no,
the
I
start.
think all he was saying was it's not surprising that if you have taken away the equivalence route, which was the route we were relying on and did have the certification in 2022.
Yes.
Once you've taken that one away, what he calls kicking the stool away,
Yes.
if we can't get that back, the only alternative
Yes.
is to do all our own clinical data. And that means testing it on pigs and students
So-
and so on, which will take ages, can't possibly be done before the thing expires.
Exactly so. And the only point that I'm making is, coming back to the way you've just phrased it, if we can't satisfy you as to that point.
Yeah.
And so it's a simple point, but just to say that there are two routes, if I can put it this way, to persuasion, and it is open to Mr. Heppenstall's
Well, I
side.
think he fully accepts that. He showed us Annex 10 to the directive, which says either or.
Well, indeed, and my lord, the simple point is that to the extent that and maybe I'm over-labouring the point, but to the extent that the threat hanging over the court is this vast volume of work, we do say that there's a rather more contained piece of work, but we have to be shown. We can't just be it can't rest purely on assertion. That's the nub of my client's concern. You can tell us it produces the same result, but you've got to show us it produces the same result. That's where we are, and that's the task before Mr. Heppenstall's client. On the QMS audit in Australia, you have the submission. We say it's a point in our favour, because what it shows is that we're not out to get this company. We haven't got some kind of animus against this company. We're conducting a perfectly proper, ongoing process of audit, and that has included saying, we've looked at your QMS processes and we think they're fine. There is no... there's nothing for Mr. Heppenstall in that. If anything, it demonstrates that my client is continuing to conduct itself as it should do and as it would ordinarily do. To the nub of the point, the alleged category error within my submissions. As I understand what Mr. Heppenstall's saying, he says that in an American sign-a-meat context, when conducting a weighing exercise, under the balance of convenience, the court should look at what, as he described it, is unsafe in a, quote, real sense. So what the court does is we take a sort of quotidian, everyday look at this. Is it going to spark, burn, or blow up? We take it, therefore, completely out of context. That's the submission. The submission is...
Oh, sorry,
yes,
his submission was not that you take it out of context. Sorry, his submission was that you apply sort of, if you like, the risk of injustice through a general look at the facts rather than through the particular eyepiece of a regulator who says safety is purely whether or not you satisfy me
yes.
of the essential requirements. He
And my
says the
submission-
court should take a more general view of public safety, not the specific regulator's view, I think.
Well, I think it goes a little further than that, my lord. I think he is asking to take it out of the context, because what he's saying is you don't need to have regard to what public safety means as regards medical devices. He's saying, I agree with Mr. Johnson and everything as regards the statutory regime, but when we come to the balance of convenience, that is not the river we're swimming in. He put it, it's not the river Mrs. Justice Laing is swimming in. She doesn't need to. And in fact, the consequence of that is that my client's conclusions as regards safety in my learned friend submission are off the table. And he has to say that because that's what Mrs. Justice Laing...
I clearly conceded that they were on the scales. I said that that was my learned friend's public safety argument at its highest, which were on the scales. It's just not a trump card. That's my only point.
Well, so we're then in a position where my learned friend accepted if my client could show a weighty factor, public interest factor, 9 times out of 10, as he put it, we would win. So I think he's either he must be saying then, yes, it's on the scales, but it's almost weightless. It's almost.
I think you're overstating it.
Well, maybe, my lord, I don't wish to be overstating it at all. I'm trying to understand the submission. The submission that's being made against me is that my client's public safety concerns go into the mix. True it is they don't appear in the judgment. So in paragraph 20, 21 and 22, the relevant paragraph, there doesn't seem to be a weighing, if I can put it that way, of my client's concerns. So he's saying they go into the weight. Were there a weighty public interest factor in the balance in a case of this kind, 9 times out of 10, Mr. Heppenstall's submission, we would win. And so it must be, I think, that my client's conclusions as regards public safety, if they're in this river at all, are very, very limited by reference to their weight. And we say that comes perilously close to what the judge has done. It comes perilously close to the judge's conclusion, which is to say public safety in this context doesn't mean what it means under the statutory regime. We take a much more rough and ready, rough-hewn approach to this, and just because you, a regulator, appointed by Parliament, not a regulator, an approved body appointed by Parliament to decide whether a device is safe, thinks it's not safe, I can airlift it out of that context and say, well, that conclusion doesn't carry any weight in my rough and ready, much more commercial view of the world. And I think that is, if I'm not mistaken, the import of the submission. The import of the submission.
I think, surely, isn't what he's doing, as I understand it, what Mr. Heppenstall is saying is this. He accepts that public safety and public health concerns go into the balance.
Yes.
Your version of public health and public safety is purely and simply and exclusively defined by the regulatory regime, such that from your perspective, public health and safety is the same whether you have an item which is actually dangerous in use or one which just doesn't work.
Yeah.
Because both of them fail to meet your certification requirements.
Yeah.
And so he says, look, you'll always win, because if public health and safety is purely coextensive with does it meet my safety requirements, it doesn't matter what it is. You'll always just say, there you have it, it doesn't meet our safety requirements in our judgment, ergo it's bad for public health and safety, ergo we win. So he's really complaining that your approach to it, you're looking at it through the monocle of the regulatory regime and your certification duty, is effectively the equivalent of just sticking your thumb in the scale. But simply saying, we are not satisfied, doesn't matter, that's as much as you need to know, Judge, we're not satisfied, ergo it's unsafe, ergo you shouldn't be injuncting us.
Well,
I mean, that's, I think, what, in essence, Mr. Heppenstall is saying. So he's not, unless I have misread him, I think that's what he is saying.
No, I think that is what he's saying. But 2 or 3 stages to the argument in response to that. The first is the consequence of that submission is that my client's conclusion as regards public safety can be, yes, in the balance, but can be, if I can put it this way, not quite turned into a feather, but can be held up by reference to another standard of public safety. We're going to apply a different standard.
Well, it can be great. Why can't he say it should be graded according to the facts? I mean, if your reason for not certifying is we are not satisfied this is not a dangerous product, and it's clear that it is dangerous, if you're right, that could be very heavy in the balance, whereas something that just doesn't work, but would have minimal other impact, is less in the balance. So it's just not a one-size-fits-all point.
My Lord, I'm not making the submission that it should be one-size-fits-all, that I get to put my thumb onto the balance, but I do make the submission that what's happened in Mrs. Justice Lang's judgment and what my learned friend is saying is, in effect, absent evidence that a device is proactively dangerous, then relief is ordinarily going to be granted in a case of this kind. So that's the first concern. The first concern, the nub of it is, Mrs. Justice Lang, this court, here's what my client says. My client's come along and said, look, we exercise our discretion to decide if the device is effective and is safe. There are almost no cases, vanishingly rare, where we actually have evidence of exploding devices. And in the absence of an evidence of exploding device, well, then this is the situation my client will find itself in repeatedly. That's the first point. The second point is that if a device doesn't work and it's a medical device, then it's not safe, or at least a medical device of this kind. Because a device...
It's like the inflatable life raft.
It's the life raft, precisely so, as my own friend very eloquently put it. So I don't accept the dichotomy, if I can put it that way. I say, on these facts, actually, we are in a situation where there is a very weighty public safety concern. My learned friend effectively concedes if that's right, then I should win. But what we have is the peculiar situation where the public authority exercising its powers has said it doesn't work and it's not safe. Or to be more precise, that's not fair. We're not convinced that it works.
Yes, this is not a case where you haven't even got positive evidence of people saying, I tried it and it didn't work. It's simply, you've not been provided with what you regard as satisfactory evidence of equivalence, and therefore, because there's no clinical data of their own, you've not been provided with satisfactory clinical evidence of effectiveness.
Exactly.
That's what the position you're in. That's your situation.
And so
you say that does engage the public safety concerns, and that the judge was wrong.
Precisely
Not
so.
just gave it the wrong weight, but she was just wrong to say this wasn't a public safety case.
Precisely so. And we say there is no category error, as my own friend
Well, I see the way in which you put that. Yes.
The category error apparently being to ask the question, in this context, what does safety mean at the very least to my client? And my learned friend seems to regard that as a category error, and we don't accept that. The second point that my learned friend made on the first ground is that my client is effectively trying to rely on the sting of the JR. We're relying on our bad decision, if I can put it that way, against him. Well, I don't put it that high. I don't say just because my client has decided to suspend that I automatically win. I don't need to, but we do know from all of the authorities that where a public body conscientiously decides that it intends to do something, that is a particularly weighty factor. So I don't say I rely on the sting in the sense that I must win, but I 100% do say that it's well established in this context that my client's decision, the fact they've reached that decision, is a weighty factor that goes into the balance. And so to the extent that that means relying on the sting of the judicial review, I say yes. That's absolutely right. That's the position in the judicial review court. That's why, when you try to prevent Ofsted from publishing a report you think is wrong and unlawful, the starting point is the court will say, well, it's a very weighty factor that we should allow them to publish. So I don't put it the way my learned friend puts it, which is to say that I rely on it to, as it was put a moment ago, put my thumb on the balance. But I do say it's very well established that my client's conclusion is a weighty factor. And that's agreed between the parties. And I don't put it any higher than that. Turning to the question whether or not the judge applied her mind to the relevant question, is this a strong prima facie case? I think my learned friend came close to accepting that he has to suggest that you read parts of the judgment together, if I can put it that way. But as your Lordship pointed out, therefore I turn to the balance of convenience. We move into the balance of convenience, we're through the threshold. And we say it's clear that the strength of the case and the need, the burden to establish a strong prima facie case, and again, that was agreed on the authorities before the judge, that is not factored into the balance of convenience in the judge's reasoning, even making allowances.
Well, it's accepted that it's not there in the language, and as you say, Mr. Heppenstall says, but you have to read that with what she said in paragraphs 19 and 20, and what she says when refusing permission. And what she says is some points are stronger than others. And I think he was inviting us to read that as being, I do think that there is some strength in some of these points.
Yeah, my lord, and I hear that entirely. But this isn't a box ticking exercise. These are the critical factors that go into the balance of convenience. They're the factors that the court has to take into account. It's not. We're not suggesting that this needed to be a judgment of inordinate length and inordinate granular detail, but it was agreed between the parties that this was something that had to go into the balance of convenience, and it's not there. It's simply not there. And just because it appears at a different stage in the judgment, where it is relevant at that point too, does not mean that the judge has properly directed herself to the question, is there a strong prima facie case? We say that she simply hasn't. Moving on
Just pause there. I mean,
yes.
if you were right, and I mean, you've made no submissions about the strength of the case.
Well, I've said I can address the court if I need to as regards to strength of the case. I was mindful of the time this morning, but you have my submission that we say, in the circumstances, we accepted that they were through the gateway, consistent with what Justice Chamberlain said. We did make submissions below about the fact that we said this is a weak case. And that is our submission. Our submission is, and I can rattle through it in, I think, under 30 seconds. The first round is that there is a violent error on the part of my client, that they haven't got the power to conduct the exercise that they've conducted. I confess I struggled with that one. I took you to Regulation 47.5 this morning. The second ground is that this was procedurally unfair. There are a plethora of complaints there, but the nub of it is either A, we didn't have an opportunity to be heard in circumstances where there was an internal appeal process. They could have sent anything they wanted to as part of that internal appeal process. B, they didn't understand the reasons for the decision. We don't understand that either because they had the assessment report. We hadn't actually reached the final decision yet, and they had an appeal. So we just don't see it. Thirdly, that it's irrational. We know that that's going to be a very, very exacting standard with an expert body applying its expertise. And the fourth is a slightly quixotic argument that we have fettered our discretion because we have conducted an investigation at the prompting and initiative of the MHRA. Now, I'm sure I've done a horrible disservice to my learned friend's statement of facts and grounds, and I'm receiving nods. So I accept that entirely. But we do say this is not a strong claim. And that was our submission before Mrs. Justice Laing. Turning finally to the mandatory order, we do say that you have DeFalco, it's been the law for a long time, relying on cases like Appellant in the non-public law context are not the same. Part of the rationale from Lord Hoffman and Lord Justice Hoffman Bridge is that this is particular to a public law context. We do say that you should follow it, but the moment that really caused concern on this side of the court, I can tell you, was the suggestion that at trial we're then going to have another mandatory order pending our decision that's going to be taken after trial if we lose at trial. And we seem to be in a situation now where there are going to be running mandatory orders against my client, requiring them to keep on a market a device that I can't prejudge what my client would decide at any point in the future, but were my client to conclude hasn't met the statutory framework, this is just going to roll its way out. So, my lord, we're very concerned about that. We say it's entirely lawful. We're not aware of another authority of that kind, and we say that, candidly, appeals to looking at the common sense and the pragmatics of this. This is not a case that warrants the breaking of new ground in the way that has happened in this case. So we say there's no authority for doing so, and that paragraph should be set aside. As regards the cost, it's agreed that the reasoning amounted to saying we could have agreed in advance, and it is also agreed that it is highly unusual to award costs in those circumstances. I won't address you any further on it. You have my submissions in writing. That's the ordinary approach, and we do say it's highly peculiar that costs have been awarded against us in this case, and we say that in the circumstances you should set that aside, particularly given the brevity of the reasoning, which amounted to not a lot more than you lost.
And are the principles in public law injunctions the same as the ordinary private law American sign of injunctions when it comes to costs?
the principles in public law injunctions as regards costs, I certainly am not aware of any authority that says there is a different approach in a public law context, and it is what ordinarily happens. You get to the end of the hearing, and then you look back, if I can put it that way. I'm not aware of any authority that directly addresses the question your lordship is asking, and I think that's consistent with my submission, the thrust of which is, again, this is an innovation, and we say it's not outside of your perimeter, and we invite you respectfully to intervene.
I think you say it is outside the perimeter.
Sorry.
Perhaps.
What you mean is the judge has wandered outside the
The
perimeter.
judge has wandered outside the perimeter. It's very much within your perimeter. Ineloquently misspeaking at the end of the day. I'm very grateful, my lady. Unless I can assist any further, those are my submissions.
No, thank you very much. Well, we're grateful to all counsel and their respective teams for some very helpful submissions. Unsurprisingly, we won't be giving judgment straight away, so we will circulate our draft judgments when they're ready in the usual way, and as you will be familiar with, they now come with a fierce embargo, which means what it says, and that is the opportunity for you to correct our typographical, grammatical errors, but not to re-argue the case or correct our reasoning. We would hope that the parties will be able to agree in order to give effect to our draft judgments, but if you can't, a composite order showing the differences with brief written submissions, and we'll deal with it on paper, and the judgment will be handed down formally, remotely in the way that is now standard. Thank you all very much.